Good afternoon and welcome to the Lawyer Assistance Program Oversight Committee meeting of the State Bar. As a reminder, this meeting is being recorded. Michelle, can you please take the roll?
Yes. Heather Benton. We cannot hear you. I do see that you're here. Oh, now I can hear you.
Yeah.
James Hiding.
Here. Hi, everybody.
Lisa Johnson.
Here.
Tracy Lesage.
Here.
Deirdre Wen.
Here.
Philip Spiegel. Has he been promoted to panelist yet? I saw that he was.
He is in the attendee pool. So Matt, are you able to promote him?
There we go. Apparently, yes. I will continue. Elise Yenny. No, it's not. And Justin Dela Cruz.
Here.
Okay. So we have, as soon as Bill, we can count as here now. So we have 7 of our 8 members. So we do have a quorum.
Can you hear me?
Yes, Phil, we can hear you.
Right.
Well, great. Thank you. Next on the agenda is call for public comment. State Bar staff will attempt to call members of the public first in the order they signed up to provide public comment. And if no one signed up, then in the order they appear in the attendee pool.
Matt, you're on mute. You can I know I see your lips moving. Unmute yourself and then go ahead.
For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the committee, please click on the hand icon now, and the State Bar staff will call you in the order that the hands are raised. For those who are participating by phone, you may wish virtually raise your hand by pressing *9. That is the star key, then the number 9. Again, doing so will alert staff that you would like to make a comment, and bar staff will call on you and open your microphone so that you can address the committee. Due to time restrictions, we cannot allow more than 3 minutes for each speaker. Please note that staff will have an on-screen countdown timer visible to all attendees during the duration of the public comment. The timer's 3-minute countdown will begin as soon as you start your comment, and you will be verbally alerted once you have 30 seconds remaining. The on-screen timer will flash throughout the final 10 seconds. Okay.
Matt, please identify any members of the public to speak, if any.
And no, there are no members of the public.
Right. Thank you, Matt. And just to confirm, there are no members of the public who have indicated they would like to give public comment. So we'll move on to the next item of the agenda, which is the chair's report. At this time, I'd like to welcome our new committee member, Lisa Johnson. Lisa, would you be so kind as to introduce yourself to the rest of the group?
Sure, thank you. Very pleased to be here. Thank you for having me. This is a great group. And I am a licensed clinical psychologist, currently working full-time as a therapist. I'm also on the board of a community mental health center in the LAX area, and was looking for another community service opportunity. And I have a friend also participating with this group on a different committee. And she said it was just a wonderful experience and talked it up very much. And that piqued my interest. And so when an opportunity came up, I looked into it and found out about this particular committee and thought this was a very unique opportunity to continue in community service. So thank you very much for having me.
Welcome.
Welcome, Lisa. I'd ask that the committee members briefly introduce themselves, and I'll start calling names. So, Phil, could you briefly introduce yourself?
Hello, can you hear me?
Yes, we can.
Yeah, my name is Philip Spiegel. I'm a physician working in the LA area in private practice and have been a member of the committee for many years. It's very, very nice to have another clinician on our committee because your input will be very, very valuable. Thanks.
Thanks, Phil. Tracy?
Hi, welcome, Lisa. I'm an attorney licensed since 1996. I'm an Orange County public defender since for the last 25 years. And we do a lot of collaborative court settings here, so this seemed a good fit for me, and I've served on the committee for quite some time as well. So happy to have you as well on your input. Welcome.
Thanks, Tracy.
Cool.
Jim?
Hi, Lisa. It's good to have you here. I'm the former state bar president in 2005 and 6 and was there as a member of the Board of Governors when the first statute came into being for the LAP and worked to try to organize that and try to set it up from the very beginning. I'm also a former president of the other bar, which dovetails and works well with the LAP to try to get lawyers and judges into recovery and to help protect the public in that way. So I just want to say it's really good. I've been on the committee, actually the Oversight Committee, for about a year and a half, 2 years, something like that. And it's been a joy. It's a different experience. So I really think that Phil hit it on the head when he said that you would have a great input, and I agree with that. So we look forward to it. Welcome.
Thank you, Jim. Heather?
Hi, I'm Heather. And I'm excuse me, an attorney, been practicing for a while, about 12 years. I am sober, have been sober since May 14, 2012. Have a heart for LAPOC and the work that we do. I also think that you will have really good input on this committee. I think some of the things we look at can be challenging for those of us who are not as familiar with the mental health and substance abuse world. So lived experience doesn't always equal education and experience. And so looking forward to working with you.
Thank you, Heather. And Deirdre?
Hi, welcome, Lisa. I'm Deidre. I am not an attorney. I'm a scientist myself. I joined the board since last year. I work with a lot of nonprofits, especially mental health in Orange County. My background is genetics and cancer research scientist. So I guess I'm, it can give some perspective from the community perspective and try to help as much as I can, but welcome.
Thank you, Deidre. And I'm Justin Delacruz. I'm an attorney, and as I mentioned before, I'm a former participant in the LAP program, so I owe my whole life to this program, and this is how I give back. So welcome again, and thanks everyone for introducing yourselves. Next on the agenda is the staff report. This item is being presented by Catherine Ongiri and Michelle Harmon.
Okay, so I will start with the support side of LAP. So in terms of outreach this year, staff has presented over 20 presentations to attorneys and law students. We are currently finalizing our 2024 presentations, and we anticipate rolling those out with toolkits for attorneys that may want to prevent education in the competency areas in their local areas. We are also exploring and thinking we're going to pilot a wellness group that will run approximately 4 weeks, and it will introduce attorneys to wellness resources and how it impacts competency. We also plan to have a statewide wellness CLE during the Wellbeing in Law Week, which is May 6th through the 10th. And what we're doing with the support groups is we are trying to see if this is a way to reach people, reach our licensees in a different way. Another support group that we are piloting is a bar prep one for repeat takers, and that is really going to provide test taking skills as well as mental health resources. And so in terms of that one is going to run during the next bar cycle, which will be, I think we're anticipating launching it probably in middle of May, beginning of June. And then we are also, the other groups that we're considering are an ADH group and maybe a practice management support group. Other jurisdictions have successful ADH groups, and there does seem to be quite a need for it. So that's probably the next one that we're going to consider running. And that's the staff update for Support Lab.
Any comments before I do mine? I see there's a hand.
Heather?
Yeah, so ADH or ABH, and can you tell us what that stands for?
Oh, it's ADHD, so attention deficit
Got it.
hyperactivity disorder.
Yes, I'm familiar with that. Okay, I missed the D, sorry.
Okay, I'm sorry about that. Yes,
That's
and so
right.
that's it. Yeah. Thank you. Anybody else have any questions? And I will just say, in terms of the mental health experts that we're using for our groups, we are drawing from our group of group facilitators. So I think that's a really great way to use them as a resource as well. Justin, did you have a question?
Yeah, I did actually. How are we advertising these or making known these resources for our membership?
Well, so what we're going to do is we're going to work with our communications office to push out the information through various channels, including, our state bar emails, LinkedIn, social media. So that's how we're planning to push out the wellness group. In terms of the bar prep group, we are hoping that we can do a little bit more targeted outreach based off of when bar results come out, and then targeting people who maybe were not successful. So that's kind of the twofold plan for that.
And is there a plan to incorporate this into our presentations that we do to law schools, at least the bar prep resource?
Yes, we will definitely. Right now, since we're just running a pilot, I think we're seeing how successful they will be. But if they are a success, which we anticipate and hope that they will be, then we definitely will incorporate it into our outreach materials and outreach presentations as well, because I mean, that's really another value and a way to kind of close some of the gaps that we're seeing in terms of people's ability to practice with competency.
Okay, thank you.
Great. Michelle, I'll turn it over to you unless there's any other questions. Heather?
Heather.
Sorry, can you guys hear me?
Yes.
Okay. I do have a question in terms of the bar prep for repeat takers. How are you discerning or determining what is the reason maybe someone's not passing a bar? So how do we how do we address that? Is it a ADHD issue that they're not aware of, or is it maybe they have a learning disability, or maybe they're just not studying right? How are you addressing that for people, or is that even something we've looked into to kind of figure out? Because we can't, of course, do a personalized kind of program to each person, but I'm just wondering, do we see any trends across the line of why people aren't passing?
So that's a really great question. And so I don't think that we have one standard answer of why people aren't passing, but what we have done is we have employed some of the, we're working with some the state about bar prep. So, oh, is my sound okay?
Yeah.
Okay, so we will be working with them, and so they do key in on those trends a little bit more, and so we'll be building 2 sessions specifically kind of around those test taking things that the academic support professionals know about, and then we'll draw on the 2 sessions for the mental health aspects that might also trying to make it appeal to as many repeat takers as possible. And maybe in time we will know, but we don't. But just depending on our experts for now.
Okay. Any other questions? I don't see. All right, shall I? On my part, I only have 2 very brief bits of information. For all the committee members, you should have gotten an email from the appointments office regarding Form 700 that needs to be filled out. And so this is a reminder for you all to complete that form. I can't really answer any questions about how to do so at this venue, but I wanted you to know that that is something that's on your to-do list. They're due by April 2nd at the absolute latest, but please get it in as soon as you can. And if you have any questions about it, or if you didn't get the email, please reach out to either myself or to Matt, and we'll make sure that you get that. The other thing I wanted to inform you of is that we did get the report from the other bar that they sent to us about their annual work. It was their 2023 annual report that's due by March 1st. So we received it in the executive director's office on March 1st. And that was, of course, a little bit late to add to our agenda and have it noticed. So the plan is to have, once we set our next meeting of this oversight committee, to request somebody from the other bar to come to this meeting and share their report with us for the year. So I want to let you know that it was all submitted on time and we have it. And if you would like to see a copy of it beforehand, I can certainly send it to you. Otherwise, the plan is to have it remediated and attached to the agenda for the next meeting. That's it for me.
Any questions for Michelle? Seeing none, the next item on the agenda is item 3A, approval of the December 8th, 2023 open session minutes. Are there any corrections or modifications to the open session minutes? Seeing none, may I have a motion and a second?
So moved.
I second it.
I apologize. Who's second? Is that Deidre?
Yeah.
So for the record, I have Heather Benton moving to approve and seconded by Deidre Wen. Michelle, please call the roll.
Heather Benson. Maybe it was my audio. I didn't hear you, but I saw your screen.
Yes. Yeah.
Okay. Jim Hiding. Also still on mute. I saw your mouth moving.
Also muted, yes.
Okay. Lisa Johnson.
Yes.
Tracy Lesage.
Approved.
Deirdre Wen.
Yes.
Philip Spiegel.
I approve.
And Justin Delacruz.
Yes.
All right, so that's unanimous approval.
Thank you, Michelle. We'll now turn to the business portion of the agenda. Next on the agenda is item 4A, update on financial assistance working group, recommendations for rule changes. This item will be presented by Michelle Harmon.
This is also a pretty brief informational item for you. The financial assistance working group, as you may remember, recommended at the last meeting that it be considered to turn our loan, financial assistance loan, into a grant as a new format. The rules, the state bar rules that govern our program have it laid out as a loan. And so there need to be changes to the rules, modifications to be able to turn it to a grant. So because changes need to be made to the rules already, this seemed like an excellent time to take a look at all of the rules and see what other changes need to be made. So our chair and our vice chair have agreed to form a working group, the two of them, to take a look at our rules and review them and see, recommend the changes for the grant and also any other changes that might need to be made. And so there's no recommendations on this item. This is only informational presentation to let you all know that at the next meeting, the plan will be for Justin and Heather to come and share with you the recommendations that they're making on what rules change need to be considered. I see, Jim, you have a hand up.
So
Your video
Justin,
is off. You must have hit the button.
oops. Yeah, how did I do that? So Justin and Heather are the working group. Is that to look at all the rules?
Yes, to start looking at the rules, the plan is for the two of them first for the staff to make some comments about what we've seen, a little bit of guidance of what we have seen that's outdated, and highlight where the financial assistance information is that will need to be updated. And then they will meet and then bring the recommendations to the full group. So that's not going to be finalized yet. They'll look at it and come to this group before the recommendation goes to the board.
Okay, thank you.
Welcome.
Jim, do I get the sense that you'd like to be part of that discussion on the recommendations?
I would like to be part of the discussion. Yeah, sure.
Okay.
Always,
Would you like
always.
to be?
It's a
would you like
control
to be-
issue.
It's all right. Would you actually like to be part of the working group?
I would love to.
Okay, so considering that one of us may have to step down, I think I'd be glad to provide support in the background, but if there's no objection, Jim could take my place on the working group.
We'll go back. Why don't we do after this meeting to check the bag leaking rules? Because I believe that we can have 3 people on it. We have done that before, is to have 3 people in a working group.
Okay.
That's correct, Michelle. You just can't then communicate to others outside of that working group on anything about this. You probably wouldn't have been able to, frankly, anyways, because the limited number of people in this on this committee. But yeah, so 3 would be just fine.
Well, great, 3's company.
So we will add Jim to that working group, and you can all look forward to that also with the next at the next meeting.
Okay. Any
questions? Sorry. Sorry, I stepped on. You're asking for questions by asking for questions.
No, that's okay. Jim, do you have an additional question, or was that from before?
You're on mute. I think that was from before.
I was saying, how do I put that hand down? Lower hand. That's how I hit it.
There you go.
Okay, thanks a lot.
All right. Seeing no questions for Michelle, we'll move on to the next item on the agenda, 4B, which are reports from the stakeholder working groups. I'll just point out that there's an attachment to the agenda. It's a memo titled LAP Oversight Committee Working Groups, some themes from stakeholder interviews. If you want to take a look at those. But we'll move on to the reports of the working groups. And the first one is the State Bar report, State Bar Court interview, and that would be me and Phil. Phil, did you want to provide any insight on that interview? If not, I can start. It's up to you.
We had a long discussion. With can't remember her name, but I came away with the sense that she really didn't have any. I think she felt that what we were already doing was satisfactory. She really didn't add anything that she felt needed to be changed.
It was Rebecca Rosenberg.
That's right, it was Rebecca.
And Phil, Rebecca, when you say there's nothing that she felt like needed to be changed, what do you mean by that? Like the direction that we're moving forward with?
Yeah, we had a quite good discussion with her, but she indicated that based upon her knowledge of the way the system is working now, that she felt that it was, appropriate. And I got the sense that she didn't believe that we needed any changes.
Okay. I had some notes that I wrote down. I might have had a different perspective, and maybe I was just projecting. So with regard to costs, I think she identified some additional costs that, and this is looking at the memo that I referenced earlier. Respondents are having to pay costs of restitution in addition to the LAP program, so that could be a barrier to participation in ADP. And with regard to process and procedures, which seemed to be a common theme, is that there was difficulty in reaching a stipulation as to whether, as with regard to the allegations of the discipline. And then we did have a pretty good discussion about eligibility guidelines with respect to moral turpitude, and whether moral turpitude is a appropriate line to draw. And based on her belief, I saw that, or she had mentioned that, she believes all matters should be open to ADP. She strongly believes in rehabilitation, and provided a little history on where that standard came from. And it was that early on in the program, ADP was open to everyone. You just needed a nexus between the actions or the conduct giving rise to discipline and some mental health or substance use disorder. And the result was there were many respondents who committed serious misconduct who could participate. And I think the Supreme Court was concerned about that. And so they've changed the rules to include the moral turpitude exclusion. And then finally, we asked her about what she knew about collaborative courts and whether that would be a good model. And she didn't have enough information to say one way or the other. But public perception might be problematic. But there's a balance between the impact of discipline on a lawyer's life, especially in the social media age. So those were my notes from the interview. I'd like to open it up to the rest of the group to see if they had any comments or questions. I don't see any. Oh, Jim. And you are on mute.
Well, it dovetails some of the discussion that we had with the OCTC, and which is the prosecutors in the state bar. At least I know Lisa probably doesn't realize that. OCTC, Office of Chief Trial Counsel, they're the prosecutors in the state bar, the disciplinary arm of the state bar, and the Association of Discipline Defense Counsel, ADDC. They all talked about moral turpitude being a difficult issue to get people into the LAP, and it affected the stipulations, and it affected the time period that it would take to get people in, and it affected the discussions, as we'll report later. But I'm concerned with the idea of public perception. And I know that we as members of the state bar and as staff of the state bar, we're always concerned about public perception, but I don't think that should be a hindrance to the program or what we do for the program. The real issue should be protection of the public, and whether or not what we do increases the ideal of protection of the public. And when you treat mental disorders or you treat substance disorders and chemical dependency, you are treating the protection of the public. You are advancing the protection of the public, irrespective of whether it's a serious offense that's involved or a minor offense that's involved. You'll still be assisting in protection of the public. And so I think that whatever we do in the future, and however this goes, that ideal of public perception, which is prevalent in our concerns right now and in the legislators' concerns right now and always, should be at least secondary and probably well down from that. So anyway, those are my comments on that. Thanks.
Thank you, Jim. Any other comments on the State Bar Court interview? Rebecca Rosenberg? I don't see any. So we'll move to the next group, and that'll be the Association of Disciplined Defense Counsel, and that would be Jim and Tracy.
You can go ahead, Jim.
I wrote this long report, so I thought I'd just defer to you. Okay, so when we talked to the ADDC, the Association of Disciplinary Defense Counsel, we spoke to the president and James Ham, President Ashad Muradian and James Ham. They're both very well-respected disciplinary defense lawyers. And we talked about the cost of the program because that was a concern that was expressed, and they acknowledged that yes, the cost can be prohibitive for some, that these people, how did they phrase it, are suspended and without a job. And so costs can be very problematic. But they thought that the major issues included the time period that it took to get into the program, and a big stumbling block was the stipulations that they had to enter into with the OCTC, the disciplinary people. So what happens is the people who apply to get in the program, and they get involved with this stipulation to determine nexus between the chemical dependency or the mental disorder, whatever it may be, and the offense, the disciplinary offense, and to determine what facts would go into a stipulation that they could present so that they could qualify to get into the program. And they felt that the stipulations were a major stumbling block in many, many cases, that the OCTC, I'll use the word bullied, would bully them into signing stipulations that included facts that either weren't true or were a little bit over the top. They would like to include facts that were mitigating or that were contrary to the facts that were demanded to be included by the OCTC, and that would be rejected. And so they didn't feel like there was a fair balancing of the stipulation, the things that go into the stipulation. So basically, the foot was on the neck of the participant by the OCTC that you sign it or you don't get in. And so we discussed the possibilities of an early hearing or early resolution meetings to resolve those issues, maybe through the use of affidavits or declarations presented to the court, perhaps by a more of a collaborative court type of approach to the ideal of entering into the stipulations, what would go into them. And so there is some work to be done that we could focus on there. But the essence would be a prompt, some kind of a prompt, whether informal or not, hearing to get the things I set forth that would go into the stipulation so that they can get on with life and get back, get things moving and into the program. So some kind of early method of determining disputed facts would be interesting. The cost, so you have the cost issue, you have some kind of early method of getting the stipulation presented and proper. And then they felt that the program did well for the people who entered in the program, but they didn't think that the program was used to the extent it could be. And I think that that they said that basically the OCTC is just too wrong too often as far as facts that would be ultimate facts that were decided by the court that they expected to have facts contrary to present, and that the moral turpitude interpretation by OCTC was many times a lot more strict than what the courts would determine. So when you have the rule that says that you don't get in if you have a moral turpitude with basically with damages or with some kind of effect, deleterious effect on the person that's affected through the disciplinary offense, then you don't get in. And so even the OCTC agreed that probably they have to take a very stringent look at this, and they take the strict view that these things involve anything gross negligence or beyond intent, all involves the ideal of moral turpitude. And so therefore, this is moral turpitude, and therefore, because it had this effect on this party, you're not eligible to get in. And they go to the courts, and the courts do assist them in many instances and are more liberal than the OCTC. That was either a complaint, I don't know, or an acknowledgement of the OCTC that the courts do assist in bringing that evaluation to a more reasonable level, or at least I would consider it more reasonable level, and allow the people in. The ADDC thinks that the program is very valuable, and if you can cut the costs and work on the stipulations, the issue of moral turpitude, everything would be much better. So now, your turn.
There's nothing really to add. We did talk a little bit about the collaborative court model. They were interested in learning more about it. They were asking me questions about it, but they didn't know enough. That seems to be a consistent theme. So if there was movement towards that direction, we probably need to get some more education out there about how it works, because they've kind of heard about it, but they don't really know how it operates. So, and other than that, and the only other thing I would mention is, the stipulation did seem to be the topic of discussion, main discussion. And I got the sense that their clients would agree to facts that they didn't believe were true, or that were skewed more favorable, right, to the prosecution side, and that they would agree to do it, otherwise they wouldn't get into the program. And that seemed to be a big problem. We did locate and figure out that there's a rule that governs that stipulation. So there was some discussion of maybe perhaps getting a rule change in the way that's generated to make it more balanced and fair. Because it does seem like clients, if they don't agree to it, I think Jim mentioned he's like, foot on throat. It's almost like they really had no power at all to impact change once it was drafted, and they just had to agree or they wouldn't get in. So, and that moral turpitude definition is a problem. I know Justin's group with Phil mentioned that they got some historical information on how that was generated. Not sure if it's still relevant to this date, but it does seem to be a barrier and causes a lot of confusion. We have that definition in criminal law, and it causes confusion. So, you have a witness that takes the stand, you can impeach them with crimes of moral turpitude. And even in our setting, it still goes back and forth what that means. So maybe focusing on those areas and the others that Jim mentioned. But I did get the consensus that they unilaterally, that when someone did get in, they did well and were likely to reclaim their livelihood and practice and not return with other disciplinary issues. So that's my 2 cents. So, and thanks, Jim, for your writing up the report. You captured everything. So there really wasn't much more to add.
Thanks for being with me on that.
You're welcome.
Well, thank you both. Any questions for Jim and Tracy on the interview with defense counsel or respondents counsel?
One other thing is I did think that the participants both in the OCTC and the ADDC, let me get rid of this call. Both, sorry, both felt that the courts could assist. And so while there might have been a feeling that the courts didn't think that they needed to do anything to improve or modify their approach to the program, I think that both the ADDC and the OCTC thought that the courts could do more to assist, maybe in somehow an early resolution of these issues.
Okay, I don't see any hands. So we can move on to the next group, and that was the Office of Chief Trial Counsel, and that would be Heather and Jim.
You want to go first, Heather? Is Heather here still? I've lost Heather. Okay.
Heather just sent an email that she needed to drop off.
She bailed out on me. Okay. All right. So the OCTC, we met with, and I'll thank Heather also for participating with us in this group. And we met with Andrew Vasicek and Cindy Chan. They're both prosecutors or attorneys in the disciplinary field, and they felt that the greatest stumbling block seemed to be cost of the program. And people had to not only pay their lawyers to fight and to argue about the discipline and do the things that you would typically think, but they had to go to all these status hearings. And so status hearing after status hearing after status hearing, and they had to pay the lawyers for doing that. And so it became pretty burdensome, as well as the testing that they have to do and the counseling, sessions and the group sessions. So all of that stuff gets to be pretty tough on people. They indicated that regarding the moral turpitude issue, they felt that the OCTC must interpret rules in a stringent way. And they are a very great sticking point. Like I said before, now, one of the things that they mentioned was they have a lot of frustration when it comes to the defense lawyer presenting a case for inclusion in the LAP or the ADP, excuse me, alternative disciplinary procedure that is going to result in a disbarment or some serious discipline that really wouldn't qualify. So ultimately, they're going to get thrown out of the bar anyway. Why should we have all of this argument and spend all of this time frustrating ourselves about whether this person should participate or shouldn't participate? And so again, there's a call for some kind of early resolution of those issues, maybe a return to the ideal of everybody gets in if they want to get in, even though this means for you, Mr. Jones, who is accused of robbing a bank and stealing money out of your trust account for the last 10 years, you're not gonna save yourself from disbarment, but you can participate in the LAP if you want to. And so you can get sober, you can get well, we can make a better society out of this, but you're not going to save yourself anywhere in regard to discipline. So maybe we should do that. Maybe that saves us a little time and effort in getting these things getting people in the program. Anyway, moral turpitude is a stumbling block. The stipulation they agreed is a stumbling block. They also pointed out that the application program should be streamlined. It takes too long. It's too cumbersome. The court could assist in some way with maybe more of a collaborative effect. The stipulations they agreed were difficult. They offered the idea of mini hearings on specific fact issues as a possibility. It was kind of a surprise to me that the OCTC the Office of Chief Trial Counsel said that there were very few instances of suspicion of lawyers trying to game the system. In other words, trying to enter into the ADP and not being actually qualified for it or not being able to benefit from it. That they felt that it was a very important thing that we do, that it was very successful. They thought it was a great benefit to the lawyers and the public. So it was quite enlightening to me, because I expected that they would say that there are too many lawyers gaming the system. It's too much, we have to be tough on people and that sort of thing. But they thought it was a great program and very valuable. We talked about having some kind of ADP worker or outside independent medical examiner try to evaluate to allow the applicant to qualify. But of course, they commented that, well, they do that all the time anyway. They have independent counsel. The disciplinary defense counsel has independent experts that they present all the time to show the nexus and to try to boost the qualification for this program for a certain person. But so they didn't think, they both sides were suspicious of that independent medical evaluation and thought that, well, you maybe could do that, but you'd have to allow an appeal process or some kind of process whereby one side or the other could say, no, not good enough. We don't want this guy in, or no, not good enough. This guy needs to be in. Either way. And so it would have to have some kind of further hearing or process that would allow somebody, if you did use that IME approach. Let's see. Now they said that the use of the ADP is relatively rare in their office, and they felt that there would be many more participants if there was no blot on the record that was included after their successful completion. And Tracy, that seems to me that would be more of a true diversion program approach, that you would have a conclusion of your successful treatment with no indication of discipline on your record. And so right now, as it stands, there's still an indication of discipline, is my understanding. But they thought, the Office of Chief Trial Counsel thought that there would be many more participants if there would be no blot on their record upon successful completion. So those were the comments of OCTC generally. Any questions? Mr. Siegel, or Dr. Siegel, excuse me. Spiegel.
Yeah, Jim, that's the way the medical board diversion program worked. Literally, after a person was, they called it graduation, but once you graduated, there was no indication anywhere that you were ever even in the program. And I always felt that was one of the points that helped get people into the program. Especially professionals are always concerned about how it's going to, reflect on them. So I know that there are some who believe that once somebody finishes a program, that there should be some indication that he did so. However, it's my belief that if we can work on a system where that remains true, I think it would be more attractive to a larger range of people. But I only look at these things from the standpoint of the program, NACA, whatever it is, and the medical issues. I'm way out of my depth once I try to get into the legal issues that you guys can do and or get involved in. But I can tell you that was one of the ways that we got more people into diversion.
I think you're right that it will attract a lot more people, but I also think it would be, realistically, it'll be a very, very, very hard sell with the Girardi history that we have now to try to get the state bar to say, oh, well, we'll just erase the record, you know, and not include anything on your disciplinary records. I don't know if they would, I don't think it'd be very welcome, but it's a proposal, you know. I think it's a correct proposal to make, but I don't think it'll sell.
Well, part of the issue is that when you have, you know, we were talking before about moral turpitude, and that if there are other issues that are legal matters involved, it always makes it much more difficult. It becomes very complicated. If we're just talking about one or two things, it's one thing. But once you get it into, especially the legal issues, then I know that really complicates things.
And, you know, with lawyers, the Association of Disciplinary Defense Counsel pointed out that lawyers have the most stringent ideal of moral turpitude, more stringent than any other profession. And so they thought that we should adopt the ideals of moral turpitude from real estate brokers and physicians and that sort of thing, and relax the standards. But as we pointed out to them, you know, you're going to have to convince the Supreme Court about that, you know, before we can do anything about that. We really don't have any control over that. That's their game. So we can't really do anything about that.
Yeah.
Any other questions or issues? Thank you for letting me participate, Justin. I really appreciated that, and it was good to participate with Tracy and Heather. We got to know each other a little bit better and got to have those interviews. They were very enlightening. Thank you.
I would agree. Thank you as well.
Well, thank you, Jim. Thanks to everyone who took time to interview some of our stakeholders. This was a really important information gathering process, and it's only the beginning, because now I'm not going to call it the real work, but additional work will come from those interviews in coming up with potential recommendations with regard to different aspects and different issues that we've identified. So, excuse me. We had a few themes, and you know, we did ask questions, and they're identified here in this memo. Broadly, we have a number of responses with regard to costs. We have a number of responses with regard to process and procedural issues, and I think the main procedural issue that I heard was the stipulation process, and how that, and relatedly, the speed at which applicant or a respondent can participate in ADP, or whether it's decided whether they can participate in ADP, the eligibility guidelines, whether moral turpitude is the appropriate standard, or some kind of other standard is the appropriate standard. And then very briefly, the collaborative courts issue. And I think based on this chart, I think more education needs to be provided or given to determine whether that is even a feasible path forward. So my proposal is to break up into working groups again, but now not just with respect to stakeholders, but with respect to issues, to formulate a recommendation for the committee to present to the board eventually. And I forgot about the timing. Maybe one of Michelle or Catherine can help me with the timing on this, kind of give an idea of you know, what the workload may look like over the next several months. Michelle, could you, or Kathy, could you help me with that timing?
Sure. Well, Kathy, correct me if I'm wrong. The plan is that these recommendations will go to the board at their November meeting. So working back from that, we would need to have the recommendations prepared, and they need to get on the board's agenda, written up, everything at least a month in advance. So we would expect that would be, we should probably aim for the end of September. So between now and September, the end of September, I suppose how you want to organize it with the committee, either having one more or two more meetings before then that we can space out to have suggested recommendations and then to write up what the board recommendations will be. Is that what you meant by time frame? Did that cover what you needed?
Yeah, that was that's what I was looking for. So thank you. I'll open up to the floor for anyone who's interested in working on one or more of the different issues, kind of going in line with the different issues identified in this memo attached to the agenda. And so with that, I'll open up to the floor for anyone who wants to express interest in a particular issue.
Justin, I didn't get a I don't know why, but I didn't get a copy of that. Is there any way can you enumerate what the issues are?
Okay, so we have the first, and they're in line with the questions we asked in our interviews. So the first issue is costs. Looking into what we can do about the costs of not only the ADP, but also of LAP, which we're also looking into, but all of the costs that are associated with entering the ADP program and participating in the ADP program. The second issue is process slash procedural issues. So those would be like whether one of the proposals was, should there be a or a mini hearing or some kind of presentation on the briefs about the stipulation of facts. That's one example. There may be others. The next issue is eligibility guidelines. So that'd be another working group. And the big issue there is whether moral turpitude should still be a bar to participation, or whether there should be another version, or whether moral turpitude should be specifically defined. Those are some of the issues or questions there. And then the last, which would be kind of a different, in my mind, a different group, is providing more education on collaborative courts. I feel like there's only one person who's really qualified for that.
That's true.
But we could also discuss, what that really looks like. Is that necessary? What has the state bar already looked into doing that? Because I know we've been talking about collaborative courts model since I've been a member of the committee. That's 9 years. So there's got to be something internal that people have looked at and put together to present to others as, is this a good idea or not? So maybe we can tag along there. So did you get all that, Phil?
Yes, thank you.
Yeah. And if you want to look at it later, our agenda, if you click on the link, if you open up on the website, if you click on the link on this agenda item, the memo should pop up.
So you were looking for volunteers for those categories then?
Yes.
So you're right. I'll be happy to help with the collaborative court one.
Okay, thank you, Tracy.
You're
Yeah,
welcome.
sorry I had to call you up, but it was just, I figured that would be the one that you'd be interested in too. So
No worries.
okay, thank you, Tracy.
You're welcome.
Is anyone interested in?
I'd be willing to help with the eligibility guidelines if that's appropriate.
Yeah, thank you, Lisa.
Okay.
I also could work with her on the eligibility. I'd like to do that.
Okay, great. When we have the opportunity for one more to participate in the eligibility guidelines, I think. I don't have the full screen up, but that looks like about right. Okay. Anyone interested in the procedural issues?
You put me anywhere. You put me anywhere where there's a space, Justin. I'll be happy to
Okay.
do any of it.
right, thanks, Jim. Do you mind working on some of the procedural issues? It seems appropriate since you spoke with both OCTC and the
Yeah, one of the
Association of
things,
Defense Counsel.
I'll tell you, one of the things that's going to be a little stumbling block for that discussion is going to be what the courts are willing to do and
Yeah.
what they won't be willing to do.
Yeah, and I think I can assist with that too. So you can put Gemini as down for the process procedural issues. Since I spoke with the representative from the state bar court, I feel like I could reach out and, you know, float ideas and see
Great.
what may or may not the court may or may not, you know, think is viable. So that's three of the groups. When it comes down to costs, I don't necessarily know if we need a group for this. I know it's an issue that was raised, but we did have the financial assistance working group to look at whether, you know, our current rules. I don't know what other things we could look at with respect to ADP that can lower the costs. I don't know, Michelle.
Well, I would like to highlight, if people had not noticed, in addition to attaching to the agenda the table with the feedback that had these commonalities of what the groups brought up laid out that Justin was referring to. The next item, business item, has a fact sheet attached to it. And so the fact sheet could be helpful to the working groups. One of the sections, in addition to talking about eligibility for the alternative discipline program, it talks about costs. And so the end of it, the end of that sheet talks about what the costs are. A big chunk of the costs of ADP is the LAP fee. People who are in ADP and the alternative discipline program are required to be in LAP. So LAP has pretty significant cost to it. So it breaks down the cost, the LAP groups, the testing, and then of course, whatever other costs are related to that person's particular treatment recommendations. So it might be a treatment program, therapy, psychiatric medication management, and if their insurance, for example, doesn't cover it, that would be out-of-pocket cost to them. And then the other costs are defense counsel if they have counsel. So regarding the LAP costs, I know this group has been doing what it can to address costs, and the group that's going to be talking about rule changes going from a loan to a grant could be a really big part of addressing this. And of course, if there is a question about it, everybody who is, if they're in the alternative discipline program and they're in the LAP, they will be eligible to apply for financial assistance. So being in ADP doesn't affect your eligibility for financial assistance. So then the other main cost would be defense counsel. And I don't know if that's something that we can or should or want to try to influence. So I don't know if this affects whether you want to make a working group about this, but that's, you know, the information we have here related to costs.
Okay, thank you, Michelle.
And then I forgot the last bullet point on here is there might be other costs that the court requires compliance with other conditions, which could include payment of restitution.
Okay, thank you for pointing that out, Michelle. And I guess I had kind of skipped stating that we're moving to the next item on the agenda. We've just been talking about it.
It flows so naturally.
Yeah, we're actually on item 4C, next steps for the ad hoc commission on discipline system regarding ADP. And we've been talking about this, so just to orient all of us. And thanks again, Michelle, for pointing this out. Yeah, and with regard to, so my thought on defense counsel costs, personally, I don't really want to be in a position to be telling people how much money they can make as part of their job. I don't really think that's my business. So, you know, unless we have someone who's being provided, you know, counsel, and that counsel is being paid through some kind of state funded program, I just don't really think that's our place. But that's my own opinion. It's one of 7 or 8. So please feel free to state another one. But that's one of the major costs where I feel like I don't feel like we could really set a schedule and say this is going to be your rate if you're going to take on one of these cases. And you know, I think the immediate response will be, if it's too low, like no one's going to take these cases, or if it's too high, no one's going to be able to afford it. So I'm kind of leaving it up to the group to decide whether or not we think we need additional, and staff, please provide input, whether we need additional looking into the costs, in addition to what, you know, Jim and Tracy have done on the financial assistance program. I got those numbers right? Those you two?
Yeah, and Phil too.
And Phil, yeah. So, I mean, there's been a year of dedicated work already on this issue. I don't know what more we can do, but I'll leave it up to the rest of the group to decide if, you know, you think that's another endeavor we should take on.
I think the most significant thing was the concept of changing these issues so that it can be a grant. I think it makes a lot of sense. Maybe we should work on exactly what we're going to need to do to affect that change.
Okay. Anyone else have any thoughts on that issue? Okay, so kind of wrapping up everything here on the next steps, I see we have 3 working groups. One for process and procedural issues, and that will be Jim and I and me. One for current eligibility guidelines, that'll be Philip and Lisa. And then so far only Tracy for collaborative courts. But we're kind of trying to define what that means, because the stakeholders don't really have enough information. It would be hard to come up with a concrete proposal for that, but that could be an educational effort. Michelle?
At that last meeting that we had in December, I remember that both Heather and Elise, Dr. Yenny, who Lisa did not have a chance to meet yet because she was not able to be at the meeting today, both expressed interest in talking about collaborative courts. So although they're not in the quote unquote room with us now, I just wanted to remind you, we can still call on their interest there too. I know you don't want to tell people what to do, but we can provide them the opportunity if they're interested.
Yeah, I think it would be good to reach out to them after the meeting to gauge their interest.
Mm-hmm.
You know, we don't have to vote on that. All right, like as long as there's 3 or fewer, they can join and provide input.
Right.
And that doesn't need to be a vote.
That sounds good to me.
Yeah, I'm sure you'd love the company.
Exactly.
Okay. So we'll rely on staff to help kind of guide us what this process looks like over the next few months. I think ideally we'd have some idea of what we want to, you know, update on our work before the next meeting, which I think is either going to be late May or early June, with a final recommendation for the committee to vote on in the fall, in September. So our next meeting will likely be late May, early June, and then the meeting after that would be during the fall.
Don't you think you're going to need 2 meetings before the September presentation?
The presentation would just be to us.
No, I mean, if we voted on a certain recommendations to go to the Board of Trustees, we'd need to do that so that it would be prepared by late September, right, Michelle?
Oh, go ahead, Michelle.
Well, so So we're talking now about scheduling the next meeting for the end of May or beginning of June. And then there will be,
Then there
and
have to
so
be
the
another
intention
meeting.
at that meeting is to present what these working groups would like to make changes in each of the areas, right? So these working groups will say, these are the process, procedures, recommendations. And then that will be written up in a formal way to present to the board for approval at this group's next meeting, which would be in September,
So
as the way it was laid out right now. But you're thinking that we need another meeting in between.
I just worry that maybe everything won't be so set and so agreeable in the next meeting as you might hope. You know, if everybody gels together and say, yeah, those are all great recommendations, and great, we're done. But if there are some open spots or some blanks that we need to fill in, which I suspect there will be, then we might need another meeting between May and September, right? I'm just suggesting that it's a possibility. I don't know.
Yeah, I think I'm open to that. So something in late June or July, early August.
Well, I don't even know if we need to set it now, but I just thought that we should make provision that in case we need it, we could do it.
Yeah. Okay. Yeah, we could do that with that understanding. And yeah, I guess you're right. Like if we're in May and we only have nascent ideas about what we want to do, and then the next thing is our final, that doesn't give much room for discussion. Before it's it'll be due in September. We need to make a decision one way or another. I think that's prudent to at least give that time. So any other thoughts on the scheduling? And with regard to the next meeting, Michelle, are we going to send out a doodle? Is that the idea?
We can do that. At the December meeting, the group seemed to think it was easier to just talk about it, which
Okay.
is how we ended up coming up with the February date that needed to be rescheduled for today. So
Okay.
for the one for today, we did one of those polls that seemed to work. Or if you would prefer to use your calendars today, we can set the next one now.
Okay, so I'll say that concludes today's agenda, with the caveat that we're going to look at our calendars and schedule our next meeting. And I have here that it's either May 24th, 31st, or June 14th. I will say that May 24th does not work for me, so but we can still meet that day. I won't be there. So I'd ask the rest of the group to take a look to see whether May 24th, 31st, or 14th work for them.
May 31 works better for me than 24th for hiding.
May 31 is okay for me.
Both May dates are fine with me. And that June date is fine too. Is that the 14th, I think? Yeah, I'm good.
Does May, so I'm gonna just put it out there. Does May 31st not work for anybody? Okay, I don't see anyone raising their hand, so let's do May 31st from 12 to 2.
All right, so we will.
Also a Zoom meeting, I take it?
Yes, it'll be remote.
We will send out an email with a calendar placeholder for that date and time.
Okay, everyone. Well, thanks for all your work today. Lisa, welcome again. And I'm sure I'll be talking to a lot of you over the next few months. So thanks everyone for your participation.
Thank you,
Have a great
Justin.
day. And the meeting's
Thanks,
adjourned.
Justin.
Good to see you all.
Bye.
You too.
Bye.
Bye.
Bye-bye.
Bye.
Will you stop the recording?